This is the American Law Journal.
You're injured at work, so you're off your feet for a while. Want to get on Facebook and tell the world? Careful, what you say could kill your workers' compensation case. Good evening, I'm Christopher Naughton, and tonight, social media, surveillance, and the injured worker. 4 guests join me. Let's go ahead and meet them. Howman Banks is a partner with Martin Banks. The firm has been on the map for decades, 25 plus years in practice for Howman, representing the claimants in workers' compensation matters. Tony Salvino with White and Williams. He goes by Tony when he's here on the program. A defense attorney, we call them respondents counselors. In workers' compensation matters, he represents the insurance companies and the corporations. He heads up the workers' compensation section for White and Williams. George Beatty has been representing injured workers now for 3 decades. I know that because George and I graduated law school the very same year. He also represents injured individuals in medical malpractice, product liability, and personal injury matters. And the Honorable Joseph Haken graces us with his presence once again. It's always great to have the judge come back and join us. And Judge, we always feel ourselves to be so lucky because we have a number of really excellent judges who come and join us. You're seated in Malvern, Pennsylvania, correct?
Sure.
That's it. Okay, good. So you hear cases just from, was that Chester County?
Chester County.
Gotcha. So every member of the panel tonight has appeared before you at one time or the other. I mean, I shouldn't wonder why they're being so very nice to you, but they do get a chance to appear before you. You know, this is a small bar association, and let me just go go rogue here for just a moment. When it comes down to lawyers dealing with each other, workers' compensation, that bar is a somewhat small bar. I hear that between defense and plaintiffs' counsel. I don't want to say they get along, famously, but there's a pretty good collegial give and take. Pretty fair group of people in this bar.
Absolutely, and very important. And the credibility of the attorney is known to every other attorney. So that if the attorney does something which is not appropriate, everyone knows about it. It's a bigger bar than it used to be. Really, there were at one time almost a handful of attorneys doing workers' comp. It has changed. There are many attorneys, but it's still a small bar, and they all know one another. And while they're good advocates, they get along for the most part well.
Well, and things change, Judge, as we know. And 10 years ago, we couldn't possibly have addressed this issue, things such as Facebook and maybe surveillance we could, but social media, it's something that is a phenomenon that's just come up in the 2000s. And is it fair to say that this has become in some ways the richest new area of discovery for both the plaintiff and the defense counsel, even in workers' compensation matters?
It's a new area in the Pennsylvania workers' comp arena. It's just starting to make its inroads. There are very few cases where we've had to deal with this. I predict, however, it's going to become more viable. There's going to be many more requests for it and many issues that be resolved. If you look at it in the final analysis, though, it's somewhat similar to asking for a diary or for letters to a friend, which they didn't do before, but now they're all stored in a particular place, like Facebook, and so they're requesting it more.
So this is, Howman, this has been on your plate now for several years, but it probably comes up every time someone comes and sits across the desk from you and you end up representing them. I bet you it comes up every time.
It does, and my advice is not to post anything during the period that you're disabled from work.
Stay off it, just completely go cold turkey.
I think for the most part, my clients don't realize that a lot of their material is public. They think if they put it on there, then it's private, and their employer and the insurance company aren't going to see it, but that's not the case. A lot of this stuff is public, and you'd be surprised what they post.
Yeah.
It's amazing.
So people don't realize that when they're posting something on Facebook or tweeting that this could be going into some defense counselor's pocket as part of the case in chief.
It's always out there. And I tell people, I don't know how practical it is or how realistic we're going to be by saying stay off completely, because people are going to get on. So I tell them a rule that I've used in my firm for many years with the lawyers and the other people and with clients, the 6 o'clock news rule, I call it. And I say, don't say anything on Facebook, don't do anything that you would be embarrassed about if it was on 6 o'clock news. So if they went on vacation at Disney World and they had to sit in a hover-around chair and went around. If you want to post that you were at Disney World, make sure you tell them that you were in a hover-around chair, okay? Don't say, I just dove into Space Mountain or something.
Right, or better yet, say nothing at all, if you could actually get them to do that.
But if they have that in their head, that the 6 o'clock news rule applies, if I say something, would I be embarrassed if it was on 6 o'clock news?
Tony Salvino, I've got to think that Facebook is the gift that keeps on giving for defense counsel.
Agreed. I absolutely love Facebook.
And not for personal reasons necessarily.
No, absolutely
right?
not. No.
So what happens? Give us, paint a picture for us here.
Sure.
Somebody makes a mistake. What kind of mistake do they make? And then how do you folks use it?
I'll tell you, I'll give you an example that we just had in the office recently. Every new file that comes in goes to my paralegal, and she just Googles the name, and you'll see Facebook, and if it's public, you can go in, and for example, they're claiming total disability, meaning they can't do any type of gainful employment, but that week they post hunting season was last week. They posted they bagged a buck, and they have pictures, and clearly the date's there, the time's there. It really helps our case that they're able to go sit in a tree or go hunting for 12 hours, yet they can't go and do a sedentary type of job. So they do. George and Sonny are absolutely correct. They have to be very careful what they post. Google is amazing, and you can find things in newspaper articles. I've had injured workers where they talk about going across country on a motorcycle, and they just put it, and there's an article in the local paper. That's clearly in the public, and that can clearly be used.
I should say something though, too. I think I need to address this, that we don't, and I'm sure I can speak for Hal, we don't want to represent people who are committing some kind of a fraud. If somebody's not really legitimately hurt, I don't want their case. Let them go somewhere else to one of these other places. But we don't want these cases. So if a person's really out there bagging a buck and saying they can't even sit at a desk, we don't want those cases. So when I tell people about the 6 o'clock news rule, I'm just saying make sure that whatever you say doesn't put you in a poor light.
Right.
But we don't want to aid and abet fraud.
Chris, it's more perception than anything else. So even if this person bagged the buck from a seated position, you got to get that buck out of the woods somehow. So if you're totally disabled and on the other hand you can carry a heavy buck out of the woods, that's a conflict.
And Tony, I suspect that some of this information comes up, right from the beginning, because I almost imagine, I mean, you told me it's your paralegal, but I told claimant's attorney before we even got on tonight, I said, I bet you Tony Salvino has someone, maybe a sharp 20-something computer geek in his office. As soon as the file comes across his desk, he's got his person going out there and going through everything. I mean, tweeting, Facebook, what else?
Yeah, no, absolutely, Chris. And I'm even going to tell you, it even happens at the insurance company with adjusters. They hire these companies that do these searches, and they go into criminal dockets, and they also go into the public arena, and they go into the MySpace accounts and the Facebook accounts, and they look for stuff that can, that either support or deny the claim. And usually, if these things are out there, if they're dancing, as Hal and George pointed out, something of that nature may not defeat a claim, but it is good fodder that we could present to the judge. You claim you can't work, but yet you can go out to the nightclub and dance for 3 hours or something of that nature.
This is similar to surveillance, and for years we've seen situations sometimes where there's surveillance, and I always tell my clients before we go in, I say, tell the truth. Because if the lawyer asks you a question that says, have you ever gone to the supermarket and lifted a shopping bag? And if it's a yes to that answer, you got to say yes, because that's not. I think Judge Hagan will say he's not going to necessarily deny somebody's claim because they put a loaf of bread in their car. But if they say they've never lifted a bag and there's a video, well, maybe he will find them not credible.
And
Judge, I'm sorry.
I was just going to say, you have the same problem with surveillance, with the whole perception idea, because surveillance is just a snapshot in time.
Right.
And unfortunately, most insurance companies don't do a day in the life. So you only see, that small little activity that the claimant is doing at that particular time.
Right. Same thing. And again, same thing with social media. That snapshot now is admissible. It's discoverable.
Absolutely.
Judge, you were going to say.
The interesting thing, too, though, is the professional responsibility of the attorney, for example, in Facebook, not to friend the individual nor to gain access without a proper representation. I'd like to pose that question to the attorneys on whether they've run into anything like that.
Not yet, but I think, like Judge Hagan said, this whole explosion of social media, it's why it's so much fun to be a lawyer, because as things progress, as our society and technology progresses, it presents us with a whole new set of challenges. How is this going to be dealt with? And I think the judge has an excellent point. If Tony's paralegal goes on and poses as some friend and illicitly friends the claimant, now that's going to be something that we may object to and be able to win that. It's too new. There are no appellate cases that I'm aware of that have decided that yet. But that's interesting things are going to happen. Also, because of the explosion of the internet, we're able to get a much better book on defense doctors. So I had a trial in August, and I had 15 transcripts from this guy, and we were able to cross-examine him in front of the jury to show that he says the same thing in all these trials. So, the internet has provided all kinds of goodies for both sides.
Right. Okay, that's interesting. Yeah, interesting point. So it's not just one sided. It's not just Tony Salvinos of the world who get to dip into the internet and into social media. Of course, you're not going to expect a corporation to put something on a social page that's going to get them in trouble later on.
Well, not a social page, but the corporation's website is often really good when you're trying to establish certain components of a product or certain things like that. That now there's websites. You don't have to try to drag it out of a corporate representative in a deposition when you have the website.
Yeah, it's all posted.
It's out there.
Let's take a look at this email. I think it's right up our alley. I got injured on the job a few months back. My foot is now in a cast, and I'm receiving temporary compensation. I got an opportunity to go away for a few days, and even though it wasn't easy getting on or off a plane, I was glad to get a break in the warmth and sunshine. I wrote on my Facebook page, having a great vacation, and when I came back, I got a call saying that I would probably be losing my comp benefits. Someone told me it's because of what I said on Facebook. How do I deal with this? Must I see a lawyer?
Yes.
Absolutely.
No question about it. And obviously, just because a person was able to get onto a plane and go sit on a beach chair in Florida maybe, doesn't mean they're able to return to work. But certainly, a post like that can lead people to go, oh, that's nice. You're not going to work, but you're going to go take a vacation. And there's that natural cynicism that we all have.
And now that the temporary compensation is being pulled, they're essentially starting over. So they're going to need to file a claim and prove that they were totally disabled from day one.
Right. Tony, when you get this information and you're banking it, if you will, at some point in time you have to divulge that to your opposing counsel, obviously. I mean, if it comes to that. I would suspect, however, probably a lot of these cases that don't never bring counsel into it because you have found some sort of damning evidence. But at some point in time, if a claimant's attorney gets involved, you've got to divulge that. Now, they're going to come up with a defense. Do you sit there sometimes and say, I'd love to see how Halman Banks or George Beatty is going to defend this one?
Sure. You do. You have an ethical obligation to turn it over as soon as, I think under the rules, and I could be wrong, but I think it's 10 days in your possession. You have an obligation. What usually happens, it's funny, we've been talking about surveillance. That was a good day when the claimant was able to do something. For example, the hypothetical use of dancing. They were dancing. The claimant will come in and say, oh, for the next week I was recuperating in bed. I couldn't get up because the dancing took something out of me or something of that nature. So you do get these novel arguments similar to what we face in surveillance, that it was just a snapshot in time, but most of the other 23 hours, the 1 hour you got, the other 23 hours I was recuperating and on pain medication, and I wasn't able to do anything.
Judge, when this evidence shows itself to you, because of the nature of where the evidence has come from, does it put you in a quandary sometimes? I mean, maybe there's some privacy issue here. Maybe you think some of this is bordering on a fishing expedition. Does this whole new brave world of social media also challenge you, the court?
Well, yeah, this is insofar as what's to be disclosed. I mean, if an individual has put the proper, pushed the proper buttons and says, look, this is really only to my friends, that's to be distinguished from what's on the public wall, say in Facebook. Insofar as surveillance itself, while it's a snapshot, usually it speaks for itself. It's either good or it's bad. If it shows the claimant doing something which he has denied the ability to do, it can be very compelling. If, on the other hand, it may turn out to be helpful to the claimant, it may actually show him limping, having difficulty walking upstairs, and the claimant himself, who has this information, could present it, although that's rarely done.
Chris, these days, some of the surveillance is actually going too far. I had a client recently who sold items on eBay, and it was discovered by the insurance company. So the insurance company used a pretext to enter his home to film items inside his home that he was selling on eBay, and he actually had to lift those items to show the individual, the surveillance investigator who entered his home. I mean, they're really going too far with the
So they
surveillance.
came into his home under a pretext, and they had a camera with them.
Correct.
Video camera with them.
Correct.
and got the guy to lift something.
To lift the items that
Right.
he had displayed on eBay.
Right.
I think they're going to have a problem with that kind of evidence.
Well, it's not the government we're talking about here. We're not talking about, you know, illegal search and seizure or some sort of constitutional right that an injured worker can claim as some sort of defense. I mean, this is a private company. Doesn't that get into a real constitutional gray area, Judge?
Well, you get into the area, however, that it's not public. You can take anything that's happening in the public, but if you deceive someone,
Yes.
and perhaps it might have a professional responsibility
Right.
on the part of the attorney if he's using any kind of deceit. For example, even under the old surveillance type of technique of giving somebody a flat tire and then suddenly saying whether you can fix it or not, that can backfire on a carrier.
I often wonder, are there many more times that their surveillance has been done and the insurance company will not give it to Tony? Like, I trust Tony. Our bar, like we said, is a collegial bar. If a defense lawyer has a surveillance, I'm going to get it. I trust those lawyers.
Gotcha.
I don't necessarily trust the insurance companies. And it's odd to me that most of the time when we see surveillance, it's bad. It's what about, because I've had some good ones. I had one where a woman's coming out of the supermarket. She's 50, her mother's 80. They're walking together with the shopping cart. They get to the trunk of the car. My 50-year-old client, who is out on workers' comp, reaches over and opens the trunk and steps back as her 80-year-old mother lifts the bags into the trunk. I showed that. I wanted that.
But how did you get the video?
The lawyer turned it over because the insurance company did the right thing.
I see.
Now,
The
how many
insurance
times
okay.
does the insurance company have video like that,
Right,
and they don't
right.
give it to Tony?
Right.
So
I
he
got
now
you.
didn't even know about it. It's not turned over to me.
Right. So they did the right thing in
They
in
did.
that instance.
They did.
So then they're not.
That helped us
they're
win the
not
case.
darkness congealed then. At least.
Not in every case.
All right. Okay.
All right, I think
Tony,
that's
go
the
ahead.
first. I think that's the first time I ever heard George say the insurance company did the right thing. So that's a momentous. Let's make sure we videotape that for posterity. Can I just add one other
Yes,
thing?
go ahead, Tom.
Just in the idea that we were talking about, even if the injured workers Facebook is not public. Their coworkers sometimes are their friends, and their coworkers see a post, and they go to the employer and tell the employer, "Hey, do you believe Joe is doing this?" And the employer then calls the insurance company, and then there's surveillance. So there's leads there, even if they believe that they're not on their private Facebooks. I just wanted to put that out there, as that we do receive that kind of lead every day.
Have you tried to subpoena non-public information on Facebook?
I have actually, I have not, but I've actually, Sonny, have spoken to attorneys who have, and Facebook is very proprietary, and they fight you tooth and nail for that record.
Really?
For those records, yeah, that's my understanding on it. And I think there's actually some federal cases going on. I don't know where they sit right now, but I do understand that Facebook is extremely guides their privacy.
Right. So they're very, very reticent to hand it over. Of course, under certain circumstances, they can be compelled to hand it over.
Yes.
And there is some federal law in reference to this aspect that is going to become vital, covering somebody like Facebook or any of the other sites of that nature.
You know, you were talking about a few minutes ago, Helen. You were talking about an adjuster or someone going into a home of an individual who was suspected of not having as bad an injury. I've discussed this, and in fact, I think I even talked to the judge about this, that there are stories of people going into doctor's offices and having perhaps having people sit in the doctor's office for a while and having someone videotaping them. Now, we know that, you know, there are certain strictures against the government doing that, but it's a real gray area when you get someone, you know, a private individual who could be an insurance adjuster or working for the insurance company or the doctor, who videotapes a person sitting in a doctor's office. Now, some people may say there's no problem with that. The person's sitting in the public. Why should there be a problem with videotaping a person sitting in a doctor's office?
We see it all the time, and a lot of times it's staged. In other words, they'll have an arrangement with the doctor beforehand and allow that person to sit for a longer period of time in the waiting room, so they can be filmed sitting for an hour or more, despite their testimony that they're not able to sit very long because of their work injury. And that's the problem with a lot of the surveillance. You don't know whether it's actual or staged, and I would venture to say that a lot of it is staged.
Tony, does anything like that ever come across your desk, and can you comment on such things?
Sure. No, actually, I've been involved in cases where we believe that the injured worker is working at a mechanics, and the insurance company has hired a surveillance company to go in and get their car fixed. And while they're there, they have a belt on with a camera. I think if it's out in the public, as Hal's or Sonny's case in which they actually go into the home, that might be crossing the line, although I don't know all the facts. But if it's out in the public, if they're outside in a doctor's office or they're at a going business and they're presenting themselves, I think they're fair game. I think that the surveillance company can go in there. As long as there's not invading the privacy of their home, I think it's fair game.
I had one where the injured person was the mother of the bride, and they went into the wedding. They found out through investigation that there was a wedding going to happen, and they showed up at the hall with a camera concealed, and they went into the wedding. And all they saw was that the injured person had to sit, didn't walk down the grand staircase. Again, it helped our case, but we were so outraged by that we sued the investigator because they had no right going into my client's daughter's wedding.
Did you prevail?
Well, it settled.
Okay.
They backed off and said, you know what, we're sorry. And then they tried to come up with some story that, oh, well, we wanted to ask the caterer, can we rent the hall? That's why we were in there. Yeah, okay, right. So.
But these kinds of questions are going to be coming up, and there are a lot of gray areas here.
So one of the first things I'll do is I'll bring the client in and sit down with the client and review the surveillance videotape as well as the report, and I'll have them explain to me, what I'm seeing. Because I want the client, obviously, to be truthful and honest with me. I don't want to pursue a claim that hinges on fraud. So that's one of the first things that I'll do. Again, it is a snapshot in time, so for the most part, it can be explained away.
Judge, I know that if a piece of evidence is gotten in front of you, it's probably there legitimately. But come on, sometimes, even if it's in front of you, don't you think that judges in general may be prejudiced how it got to this court of law, how it got in front of you?
Well, it depends on what that particular piece of evidence is. For example, if it is a video, the video does kind of speak for itself. I mean, you can see what's occurring. Now, if they've acted improperly, for example, you're talking about the doctor's office. Well, if that doctor's going to be testifying, and if it turns out that the doctor was somehow in collusion with the surveillance people, his testimony is not going to be very trustworthy. Any examination made by that doctor, if he would be doing something like that. So it could reflect on other pieces of evidence. But video in and of itself, though, usually speaks one way or the other. I mean, it does show activity or lack of activity. For example, if on the same day, even though it's a snapshot, if on the same day after visiting the doctor indicating that he cannot do any work, for example, and then they immediately take surveillance and a video that shows him working immediately on the same day within hours, that's going to be compelling.
Judge, can I ask you, when you get surveillance film, do you want to hear from the claimant? Do you want to hear the claimant try and explain it away?
Well, most of the time what actually occurs is that the claimant agrees that in fact this is the claimant on the video, and then the claimant ought to explain if in fact there's something to explain. The absence of testimony can have that feeling, well, you're not explaining it away. And therefore, it gives more legitimacy to the video and the surveillance, no matter what it is.
I think another issue that gives us the ability to be creative. That's another great thing about our job, is that we can think outside the box and be creative. And sometimes the lack or the failure to produce video can result in a big win. And that's happened to me in third-party context against a casino, where there should have been video of a certain incident occurring because there was a camera right there and it was requested right away and they couldn't produce it. It's happened in a workers' compensation case recently where there was security video trained on a certain area where this incident happened, and they had videotape of it and they couldn't produce it in court. And there's a presumption that if a party should have possession of evidence and they can't produce it, there's a presumption that had that evidence been produced, it would be bad for them. So it's helped us in comp cases, it's helped us in third-party cases, and this is happening more and more because there's so much there's so much security video out there now that didn't used to be there years ago.
So we know that if someone is working with a claimant's attorney, they know right from the get-go their attorney is going to warn them about Facebook, and they're going to warn them about any kind of social media, blogs, anything that can get out there into the world of the internet. What about surveillance? I mean, how many cases do you think, what percentage, if you had to come up with a number, do you think where an insurance company is really going to take a camera and go out and find your guy and videotape
Not
them?
very high. I don't think it's
Like 5% of the time, maybe?
Maybe.
Okay, all right. But it's something you'd still have to warn your client about.
Absolutely, because it can be so damaging.
Right.
I, for the most part, tell all of my clients that you need to understand that the insurance company can do surveillance, and they can catch you doing an activity that, viewed in such a small, limited context, can appear as if you're doing something outside of your stated restrictions. So you need to be careful.
Right. I think you had a client once, George, that was showing someone how to use a lawnmower or something.
Right. And the funny thing was that she said, I had to teach my 10-year-old son how to mow the lawn because I can't do it anymore. And the surveillance that they had was her showing this little boy how to mow how to turn the lawnmower on.
Once again, someone doing the right thing on the insurance side of the ledger. Hey, Tony, I think that's 3 times in one show. Okay?
Or lightning's going to hit us.
It's a new record.
Just to follow up everyone's point, I do think George made an excellent point. From the employer's perspective, if there is a surveillance camera or some type of investigative camera, please preserve that for the case, because that is critical. And the claim's going to come in and say that the injury happened a certain way. There's nothing better than the actual film of the injury. If you have it. So I think that is critical on that. So I just wanted to reinforce George's point there from the employer's perspective.
I'm going to leave the last words here to the good judge. Judge, if you could, I don't know if you can synopsize what this area is coming to, what it's about, but what does it mean for the practice of workers' compensation and the workers' comp system?
I think what it means is that workers' compensation was initially to be a very simple system. Swift, quick, and with payment, and get the man back to work. I think this is going to make it more complicated, making it more of a federal kind of case. It's a new item. It's there. People are using it. The lawyers are going to want to look into it. I think it's going to make workers' comp more complicated.
Interesting observation. We'll have to leave it there tonight, folks. If you need more information, it's simple. Go to our website, lawjournaltv.com. Call us toll-free, 888-78-LAW-TV. Write to us at info@lawjournaltv.com. You can tweet us, visit us on Facebook, go to the American Law Journal and get your law on demand. Again, I want to thank my guests, Halman Sonny Banks with Martin Banks in Center City, Philadelphia, representing the claimants, Anthony Salvino, the chair of the Workers' Compensation Practice Group with White and Williams, George Beatty, representing claimants and plaintiffs in workers' comp and personal injury matters, respectively, and as always, the Honorable Joseph Haken, who sits in Malvern, Pennsylvania, and has been doing so now for the last 2 decades. For all of us here at the American Law Journal, I'm Christopher Naughton. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Beatty, Sloan, and DeGeneva, personal attention for those hurt at work or suffering from serious injury. Martin Banks, we wrote the book on workers' comp law. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.